नमस्कार मंडळी. मी प्रसाद अथणीकर, महाराष्ट्र मंडळ शिकागो 2023 चा अध्यक्ष. तुम्हा सर्वांचे आजच्या अर्थविचार आणि फॉरेव्हर यंग आपल्या सीनियर्स ग्रुपच्या संयोजनाने हा सेशन आपण करत आहोत. विशेष अतिथी आहेत, आपलेच मेंबर आहेत, पण प्रोफेशनल आहेत, त्यामुळे आपण हे YouTube लाईव्ह पण करत आहोत. तर YouTubeवर जी लोक आता बघत आहेत त्यांनी पण आपले क्वेश्चन्स चॅटमध्ये लिहावे. आपण त्याचे पण दखल घेऊया आणि ज्यांना इथे क्वेश्चन असतील त्यांनी पण चॅटमध्ये लिहावे. Monica, just for your reference, you don't need to worry about adding people as well as you don't need to worry about looking at the chat at this point. Once the session is over, one of us will read down all the chats and see if there are any questions, and then you can answer them. And Maroda and other admins are co-host, and they will take care of admitting people. So मी आता विनंती करतो मारोदा, जे आपले इसी लिएजन आहेत फॉरेव्हर यंग ते, आपल्या पाहुण्यांची ओळख करून द्यावी आणि सेशनची सुरुवात करावी.
धन्यवाद प्रसाद. नमस्कार मंडळी, मी माधव गोगावले, महाराष्ट्र मंडळ कार्यकारिणीचा सदस्य. त्याचप्रमाणे प्रशांतने सांगितल्याप्रमाणे आपले फॉरेव्हर यंग ग्रुप, ज्येष्ठ नागरिक, अध्यात्मपीठ, इतिहास मंच आणि साहित्य कट्ट्याचाही आयोजक म्हणून काम करतोय. आणि आज विशेष आनंदाची गोष्ट मला सांगावीशी वाटते की आपल्या महाराष्ट्र मंडळाच्या अगदी लहान बालक जे काय वाढलेले आहेत आपल्या महाराष्ट्र मंडळ शिकागोमध्ये, तर त्यातलेच हे दोन आज आपल्याला एक सुंदर प्रोग्राम सादर करणार आहेत. बऱ्याच वेळा आपल्याला काय होतं की ज्या वेळेला आपण ऐकतो विल ट्रस्ट असलं नियोजन म्हटलं की भीतीचं वातावरण तयार होतं, किंवा आपल्याला वाटतं की आपण कशासाठी हे करायचं, आपल्याकडे काय एवढी पैसा नाहीये किंवा असं नाही, मला काय जरूर नाहीये. पण खरोखर याची सर्वांसाठी अतिशय गरज असते. ते का, कसं, काय ते आज आपण ऐकूच. तर मला अतिशय आनंद होत आहे की आजचे जे आपले सादरीकरण करतायत मोनिका आणि अमया, हे आपल्या शिकागोतच वाढलेले आहेत. मोनिकाने युनिव्हर्सिटी ऑफ नॉटर डेम त्या ठिकाणी तिने लॉचं स्कूल शिक्षण घेतलं. त्यानंतर तिथं JD मिळवली. त्याचप्रमाणे नंतर मग सेंट लुईसमधील वॉशिंग्टन विद्यापीठात तिने MLA प्राप्त केले आणि तिथं कर आकारणी याच्यामध्येच मेजर होता. आणि मोनिका गेल्या अनेक वर्षापासून MMC शिकागोची स्वयंसेविका आहे. तुम्ही पाहिलंय असेल की प्रत्येक कुठलाही कार्यक्रम असला की पाटणकर फॅमिली नेहमीच तिथं असते. आणि विशेषतः मोनिका ती तर अगदी हमखास असतेच, तिला कधीही विचारा, ती नाही म्हणत नाही. त्याचप्रमाणे तिचे धाकटे बंधू अमय पाटणकर याने देखील सेंट लुईस विद्यापीठातूनच पदवी घेतली. आणि त्याचप्रमाणे नॉर्थ वेस्टर्न विद्यापीठातून त्यांनी टॅक्सेशनमध्ये MLM केलेलं आहे. पाटणकर लॉ फर्म ही केवळ एक लॉ फर्मच नाहीये, तर त्या ठिकाणी विशेषतः इस्टेट नियोजन, रिअल इस्टेट खरेदी विक्रीचे ते प्रतिनिधित्व करतात. कौटुंबिक कायदा म्हणजे फॅमिली लॉज, एनिथिंग समबडी हॅपन्स, वैयक्तिक इजा, कोणाला काही हे झालं असेल ऍक्सिडेंट वगैरे किंवा रहदारी, अशा अनेक कायद्याच्या इतर क्षेत्रावर ते लक्ष केंद्रित करतात. त्याचप्रमाणे पाटणकर, तुम्ही जर आपलं रचना पाहत असाल किंवा वेगवेगळे प्रोग्राम पाहत असाल तर त्याच्यामध्ये ती नेहमीच अगदी विथ प्राऊड अभिमानाने ती आपली स्पॉन्सर असते. त्याचप्रमाणे मराठी शाळेचेही ती स्पॉन्सर आहे. त्याचप्रमाणे हे दोघंही पाटणकर लॉ PC फार्मचे ते दोघ जण भागीदार आहेत. तर आज इस्टेट प्लॅनिंग बेसिक्स या विषयावर आपल्याला ते चर्चासत्र सादर करतील. तर मी अधिक वेळ न घेता मोनिका आणि अमयला विनंती करतो की तुम्ही आपलं सत्र सुरू करावे. मोनिका.
What is going?
Uh, Monica, your video is freeze. Okay. I think Monica, are you there?
We're back. Thank you.
Okay. Okay. Let's start.
Okay. Well, thank you so much to Maharashtra Chicago for inviting us today. Thank you to Prasad Lathanikar, our president. Thank you to Madhav Kakagowale. Thank you to Mandar Zogrikar. Also want to thank the Forever Young Committee and the Arthavichar Committee. It's so nice of you to invite us today to speak about this very important topic. Today we're speaking about estate planning basics. So this is just an overview of the general concepts of estate planning, what it means, what are the different documents involved, and basically how the process works. So there are 3 important points that we're going to discuss today. Today you will learn about the advantages of estate planning. You'll learn how to protect your and your family's wealth, and you'll learn how to protect your Okay, hope you can hear me. We have created a PowerPoint presentation for you to follow along at home. And just to reiterate, our 3 main points for today are: you will learn about the advantages of estate planning, you will learn how to protect your and your family's wealth, and you will also learn how to protect your family's well-being. So let me start the PowerPoint presentation so you could easily follow along at home. And just to introduce myself, I'm attorney Monica Fattenkar, and this is?
I am Monica's brother, attorney Ameya Fattenkar.
So you may have seen us at various events. Maybe we worked with you in the past. You may have seen our ad in the Rachna, but next time we do see you in person, please stop by and say hello. So I'll start the presentation now.
Yes, we can see it.
Okay, perfect. Okay. Presentation bit. Okay. So Mandar, are you there?
I am. Yes, I am here.
Okay, so Mandar and I had a chance to speak a few days ago, and we were talking about what his experience was with estate planning. And he brought up some really important points. I thought we would share that conversation with everyone. So Mandar, in your opinion, why is it important for our community to learn about the estate planning process?
Great. Thank you for that question, Monica. नमस्कार मंडळी, मी मंदार जोगळेकर, MMC 2023 अर्थविचारचा ऍडमिन. या प्रश्नाचं उत्तर असं आहे की आपण जे इथे बॉर्न झालेले नाहीयेत, तर आपण इथे इमिग्रेट होतो H1 व्हिसावर, त्याच्यानंतर आपल्याकडे ग्रीन कार्ड येतं, आपण सिटीजन होतो. पण ह्या सगळ्या ह्याच्यात ज्यावेळी आपला संसार असतो, आपली मुलं असतात, त्यावेळी आपल्याला एक गोष्ट प्रकर्षाने जाणवते की आपण जे काही कमावलेलं आहे ते योग्य पद्धतीने लीगली आपल्या मुलांपर्यंत कसं आपल्याला पोहोचवता येईल. म्हणजे आपण त्यांच्यासाठी काही 529 केला असेल, किंवा त्यांच्यासाठी काही रिटायरमेंट अकाउंट केली असेल, किंवा आपण आपल्यासाठी काही रिटायरमेंट अकाउंट्स केली असतील, तर ह्याचा सगळ्याचा फायदा आपल्या मुलांना कसा होईल ह्याच्यासाठी हे इस्टेट प्लॅनिंग अत्यंत गरजेचं आहे. आपल्यालाच नाही तर अनेक जे इथे बॉर्न झालेले आहेत त्यांना सुद्धा हे अत्यंत गरजेचं आहे. आणि ह्या विचारातनं मी मोनिकाला अप्रोच झालो, आणि ऑफकोर्स मोनिका आणि अमय या दोघांनी आम्हाला अत्यंत चांगली सर्व्हिस दिली. सो थँक्यू व्हेरी मच, मोनिका.
Thank you so much, Mandar, for those kind words. So that is a really interesting point that you brought up. So how did you personally decide to do your estate plan? Like, how did you come to the decision that it was time for your family and your wife and you to sit down and really do this process?
अगेन ग्रेट क्वेश्चन. असं झालं की मागच्या काही वर्षात आपल्याला माहिती आहे की आपण कोविडच्या पॅन्डेमिक मधनं गेलेलो आहोत, आणि ह्या पॅन्डेमिक मध्ये दुर्दैवाने अनेक लोकांचे मृत्यू झालेत, आणि ही अत्यंत दुर्दैवाची गोष्ट आहे. अचानक निसर्गाने ज्यावेळी आपल्यावर किंवा कोणावरही आपल्या लव्ड वनवर घाला घालतो, त्यावेळी आपण भांबावलेल्या स्थितीत असतो. त्यावेळी आपल्याला आपला पहिला विचार येतो की आपलं काय होणार, आपल्या कुटुंबियांचं काय होणार, आपल्या लव्ड वनचं काय होणार. ह्या पोस्ट कोविडच्या काळात सर्वात मला एक प्रकर्षाने गोष्ट जाणवली की जे काही आपण केलेलं आहे त्याचा आपल्याला फायदा तर झालाच पाहिजे, परंतु दुर्दैवाने आपल्याला काही झालं, किंवा आपल्या बायकोला काही झालं, किंवा आपल्या पार्टनरला काही झालं, तर ह्याचा फायदा आपल्या मुलांना किंवा आपल्या नेक्स्ट जनरेशनला कसा होईल. आपण इकडे घर करतो, आपण इकडे आपल्या काही स्टॉक इन्व्हेस्टमेंट असतात किंवा काही रिअल इस्टेट इन्व्हेस्टमेंट असतात किंवा कुठलीही इतर इन्व्हेस्टमेंट असते, तर आपण जर आपल्याला जर काही झालं तर त्याच्यानंतर हे एक तर स्टेटकडे जातं किंवा ह्याचं काय होतं, अनलेस अँड अंटिल तुम्ही त्याला डेसिग्नेटेड ऑथॉरिटी देत नाही दुसऱ्या कोणाला तरी की मला जर काही झालं तर यांना ह्याचा फायदा मिळावा, ते लिगली कोणीही काही करू शकत नाही. आणि म्हणून मी आणि माझ्या मिसेसनी बोलून आम्ही हे सगळं करण्याचा प्रयत्न केला. आणि अगेन मोनिका अँड आम्ही हेल्प अस अ लॉट. सो थँक्यू वन्स अगेन.
Thank you, Mother. And then how did you feel after you completed your estate plan? Like what was your feeling after that?
बेसिकली हे जे इस्टेट प्लॅनिंग आपण करायचं असतं, दॅट इज आय कॉल इट ॲज अन ॲडेड इन्शुरन्स अँड अ पीस ऑफ माइंड. त्यामुळे हे एक तुम्हाला पीस ऑफ माइंड आणि ॲडेड इन्शुरन्स अशासाठी आहे की ठीक आहे, उद्या मला जरी काही झालं तरी माय लव्ड वन आर गोइंग टू बी टेकन केअर ऑफ. अर्थात माणूस जाण्याचं दुःख हे आयुष्यभराचं असतं, ते कोणीही भरून काढू शकत नाही. परंतु माणूस गेल्यानंतर त्याचं जे काही असतं, त्यांनी जे काही कमावलेलं असतं, शेवटी आपण कोणासाठी कमावतो? आपल्या नेक्स्ट जनरेशनसाठीच कमावतो, राईट? त्यामुळे त्यांना ते व्यवस्थित जाणार आहे ही भावना आमच्या दोघांच्या मनात असल्यामुळे खरोखरच पोस्ट कोविड आज आम्ही रात्री शांत झोपू शकतोय की ठीक आहे, उद्या दुर्दैवाने जरी काही झालं तरी आपल्या मुलांचं दे विल बी टेकन केअर ऑफ. आणि हे जे एक पीस ऑफ माइंड आहे, हे ह्याच प्रोसेसनी म्हणजे इस्टेट प्लॅनिंगनी तुम्हाला मिळू शकतो. म्हणून मी सगळ्यांना अगदी आग्रहाचं विनंती करेन की ह्या आजच्या सेशनकडे खूपच सिरियसली घ्या आणि तुम्ही मोनिका आणि आमेयकडनं तुमचं इस्टेट प्लॅनिंग करून घ्या, कारण या पोस्ट कोविडच्या काळात ते खूप गरजेचं आहे. इट इज अन ॲडेड इन्शुरन्स अँड इट गिव्स यू अ ग्रेट पीस ऑफ माइंड फॉर शुअर. थँक्यू मोनिका.
Thank you. Okay, and last question, Mother. Why do you think that many people don't think about estate planning?
Yeah, again, great question. आपण भारतामधनं येतो, जे विद्यार्थी दशेत येतात ते खिशात $10 ते $15 आणि स्कॉलरशिप घेऊन येतात. बाकीचे जे प्रोफेशनल म्हणून येतात ते सुद्धा काही मोठं डबोलं घेऊन येत नाही. आपण इथे झिरो पासून सगळं सुरुवात करतो आणि त्याच्यानंतर ज्यावेळी आपण एखाद्या अशा स्टेजला येतो की ठीक आहे, आता आपलं घर झालेलं आहे, थोडेफार पैसे आपले बँकेत सेव्हिंगला आहेत, थोडंफार इन्व्हेस्टमेंट आहे, तर त्याचं आपल्याला सदुपयोग आणि ज्याला आपण सविनियोग ज्याला मी म्हणतो ते करण्यासाठी हा मार्ग आहे. आणि कित्येक लोक असा विचार करतात, अरे माझ्याकडे काय $1 मिलियन नाही, माझी काय बरीच रिअल इस्टेट इन्व्हेस्टमेंट नाही, माझं काय स्टॉक पोर्टफोलिओ नाही. हे चुकीचं आहे, असं करू नका. तुमचं एक घर जरी असेल आणि तुमच्याकडे फक्त एक सेव्हिंग अकाउंट जरी असेल आणि तुमच्याकडे कुठलीही स्टॉक पोर्टफोलिओ किंवा कुठलीही इतर इन्व्हेस्टमेंट नसेल तरी सुद्धा हे करणं अत्यंत अत्यंत गरजेचं आहे. आणि तसंच तुमचा मिलियन्स ऑफ डॉलर्सचा स्टॉक पोर्टफोलिओ असेल किंवा तुमचा मिलियन्स ऑफ डॉलर्सचा रिअल इस्टेट पोर्टफोलिओ असेल आणि अगदी खूप मोठं सेव्हिंग असेल तर फारच चांगलं. त्यांच्यासाठी तर हे अत्यंत गरजेचं आहे, म्हणजे त्यांनी तर करायलाच पाहिजे. पण आपली माणसं असं करत नाही, ते म्हणतात अरे माझ्याकडे कुठे एवढी इस्टेट आहे. इस्टेट प्लॅनिंग किंवा ट्रस्ट प्लॅनिंग या शब्दावर जाऊ नका. लिगली आपल्या हेअर्सना म्हणजे आपल्या लव्ड वनना, आपल्या बाळांना आपण जे काही कमावलेलं आहे ते कसं मिळू शकेल ह्याच्यासाठी हे उपयोगी आहे. आणि या कारणासाठी आपली माणसं करत नाहीत, ते थोडे बुजतात. तसं बुजू नका, कोणीही बुजू नका. तुमचं घर असणं ही तुमची इस्टेट आहे, तुमचं बँक बॅलन्स असणं ही तुमची इस्टेट आहे, तुमचं रिअल इस्टेट इन्व्हेस्टमेंट असणं ही तुमची इस्टेट आहे आणि तुमचं स्टॉक पोर्टफोलिओ असणं ही तुमची इस्टेट आहे. त्यामुळे करा, जरूर करा आणि लवकरात लवकर करा. तसंच तुम्ही जर अपार्टमेंट मध्ये जरी राहत असाल तरी सुद्धा तुमचं चेकिंग अकाउंट असेल, तुमचं सेव्हिंग अकाउंट असेल, दॅट इज युअर ऍसेट. त्या ऍसेटचा विनियोग दुर्दैवाने आपल्याला जर काही झालं तर आपल्या बाळांना त्याचा उपयोग व्हावा याच्यासाठी हे करा. आणि आपली माणसं, मराठी माणसं थोडी बुजतात ती ह्या कारणासाठी. ते विचार करतात माझ्याकडे कुठे एवढी मोठी इस्टेट आहे, असा विचार प्लीज करू नका. माझी सर्वांना आग्रहाची विनंती आहे, प्लीज हे सेशन ऐका आणि मोनिका आणि अमेयाला कॉन्टॅक्ट करून रिअल इस्टेट म्हणजे हे इस्टेट प्लॅनिंग किंवा ट्रस्ट प्लॅनिंग करून घ्या. थँक्यू.
Thank you so much, Mother. I think you brought up a lot of important points and a lot of misconceptions. So let's talk about what the estate plan is and what we need to do to make it happen. So So let's talk about some goals for this session. So during this session, we will talk about the different components of an estate plan. Many people have heard of a will or a trust, but there are other important documents such as a power of attorney and for healthcare and power of attorney for property as well. And when we talk about the relevance in today's climate, we'll all remember COVID-19 just 3 years ago. It was a very scary experience. What the pandemic taught us is that there are things beyond our control at different times in our life. And it's really important to be prepared in case something bad happens. So now with COVID-19 mostly behind us, what we can do right now is take control of our family's finances and plan for the future when there's no pandemic happening. We will also discuss what happens when you don't have an estate plan and someone passes away or becomes sick. We will talk about what happens and what plays out in that scenario. So just as a disclaimer, this presentation today is for Illinois estate plans only. The laws for estate planning, they differ by each state, they differ by each country. So if you're watching this session outside of the jurisdiction of Illinois, make sure you consult an attorney in your state or the country that you're in. At the end of the session, we will do a question and answer. So during this presentation, if you think of something that you want to ask me, go ahead and write my email address down and you can email it to me, or you can also put it in the chat here on Zoom. So I'll just give a second for everyone to write that email address down. Just my first name dot last name at gmail.com, monica.pottenker@gmail.com. Okay, so we'll move on to the next slide here. First important question, why do I need an estate plan? And I think Mandar definitely covered why. So the first reason is there's a common misconception that estate plans are just for elderly people or sick people, but that's just not the case. So if you have children, you own any assets, you own a house, and have plans to leave money behind to your family, you need to put those wishes into place before something happens to you. So this estate planning process, this is really for everybody. Everyone needs an estate plan for their personal situation. For example, a single person with no house, they may need a different estate plan than maybe a married couple with a house, a rental property, and investments. So with an estate plan, we're not always talking about passing away. There are some documents that we create that actually govern while you're alive, but you're incapacitated. So it's really important to have all of these documents completed. So what exactly is estate planning? So the concept of estate planning is just an umbrella concept. So for all the documents that we create, this goes under the umbrella of estate planning. When you work with our firm, we generally create the following documents. We create a will, a revocable living trust, a power of attorney for healthcare, and a power of attorney for property. So I have a lot of clients call me and they don't know much about estate planning, but they just say, hey, Monica, I need a will. So I know that that's a common term that everyone has heard of, but the will is just actually one document that we need to put into place to allow you to pass your assets to your family members. Most people watching this Zoom, they actually need a will and a trust along with other documents. To summarize, so the estate plan is really a method for using and transferring your property and making decisions for your care during your lifetime and your passing. So let's start with a common term everyone has heard of. What is a will? So a will is a legal document that takes place at death, takes effect at death. The will name an executor who will be in charge of wrapping up your affairs. So usually when we have a married couple, each person generally names the other as the executor. And then we also have that person name a backup executor. So that backup executor can be a child who's over the age of 18 or another trusted adult, like maybe your brother, your sister, a parent, or a family friend. Another very important point in the will is that there's a guardianship provision. So if anyone is watching on the Zoom who has a child under 18, you really need to pay attention at this point of the presentation. The will has a guardianship provision where you can name a guardian or person to take care of your children if something were to happen to you. So this is really important to make sure that there are no disputes. If God forbid you pass away and you don't have a will, can you imagine what your family would do? There would be kind of a family feud or a fight over who would raise your children, who would take care of them. So in order to avoid all that, we put a guardianship provision in the will. So our clients will tell us, hey, if I pass away, I want my brother, my sister, my parents to actually raise my children. Additionally, if any of our viewers today on the Zoom have a special needs child, we want to include a special provision for that special needs child in our estate planning documents. So make sure if you go forward with doing an estate plan, you actually do mention that you have a special needs child. If you have a special needs child over the age of 18, that child may need a guardianship. And we also do those in our office. So please contact our office and let us know if you are doing an estate plan that your child has special needs. The next document we're going to talk about is a revocable living trust. I think most people have heard about what a trust is, but this concept of revocable living trust is very important. So a trust is a document that describes how you want your property managed during both your lifetime and at passing. So what I do is I think of the revocable trust like a candy jar. So the trust is the jar, and then the assets in the jar are the candy. So from the last slide, which was the will, a client chooses an executor, but for a trust, the client chooses a trustee. So for example, if there's a married couple, both will serve as co-trustees during their lifetime. When one of them passes away, the remaining person will be the sole trustee. And when both people pass away, that client will have named a successor trustee. And again, that successor trustee can be a child, adult child over the age of 18, a brother, sister, parent, or another trusted family member. A lot of my clients don't have any family living in America, so it's perfectly acceptable to choose a trusted family friend because you're not alone. There are a lot of people here who don't have any family, so you can always choose each other. Just make sure it's someone that you trust. So the most important reason for doing a trust is to avoid probate. If you own a house and you pass away without putting your house in a trust, generally, the distribution of your estate will be decided by the court in the county that you live in. That's what's called the probate process. The whole point of doing this trust and this will is to avoid the probate process. You don't want the court involved in passing the money that you have to your children because it takes a long time, it's very expensive, and it becomes a public process. So the reason for doing the estate planning and the revocable trust and the will is to make sure that everything is put into place so that the court is not involved in this process after you pass away. One important concept in the trust is that we make sure the property in the trust is conveyed to your heirs in a timely manner. So in Illinois, children can actually inherit property at age 18. So what we make sure our clients know that they can actually put an age restriction in the trust. I don't know many parents who would want their children, if they're very young, 18, 19, 20 years old, to inherit all of their estate at such a young age if they were to pass away. So what we recommend is that you put a direction in the trust to say that maybe your children get one half at 25, one half at 30, one half at 30, one half at 35, whatever age you feel would be appropriate for your children to actually inherit that money. In our documents, we actually make a provision that they can actually get that money before they reach that age for things like college or basic living expenses. Finally, the trust that we're going to set up has to be funded. So generally, we fund this trust with your primary residence. So we actually transfer the deed from yourself into the trust. Now, in order to talk about these other documents, I will turn the presentation over to Attorney Amaya Prottenker, my brother, and he will lead you through the power of attorney for healthcare and power of attorney for property.
Okay, thank you, Monica. So the next two documents that we are going to go over are very important. These two documents are the power of attorney for healthcare and the power of attorney for property. These two documents will allow your loved ones to make decisions for you if you are ever incapacitated. So they will be very valuable to you if you're alive, but you're incapacitated. So the first document I'm going to go over with you is the power of attorney for healthcare. And this is the form that allows you to choose a person to make your healthcare decisions when you cannot make them for yourself. The person that you choose is called the agent. And the agent can make your healthcare decisions when a physician that is treating you deems you as incapacitated, meaning you are now unable to mentally make your own decisions. Or the agent can make your decisions right away if you choose that option on your power of attorney for healthcare when you are executing it at our office. The agent that you decide to make your decisions, they have a duty to act in good faith on your behalf, or they can be removed as the agent if a judge deems that abuse of discretion has occurred in your situation. Now you may be wondering, who would act as my agent? Well, an agent can be your spouse, a really good friend, a relative, all people you trust to make important decisions for you. You cannot have co-agents. So if you want to select someone to be your agent, or you have a couple of people you'd like to put, you have to choose them in order. So we'd actually put them in order of how you want them to act. So you can appoint successor agents as backups after the first person acts, if the first person you listed cannot act on your behalf. Keep in mind that the power of attorney for healthcare must be created while you have the mental capacity to sign the document, meaning you have to be able to make decisions for yourself. If you've already lost mental capacity, you can no longer execute a power of attorney for healthcare or modify a power of attorney for healthcare if you've already executed it. At that point, somebody would have to get a guardianship over you, which is a court procedure, which is something that we're going to discuss a little bit later in the presentation. Now, you inevitably decide the range of powers that your agent has, whether they be very broad or very limited. But the types of things that the agent can do for you can be making your healthcare and medical treatment decisions, making your end of life decisions if that type of situation arises, deciding whether to admit or discharge you from a healthcare facility, and even to authorize an autopsy or donate organs for medical research. So your agent does not need to sign the documents that you are signing. You only really need to ask those individuals that you are going to list on your power of attorney for healthcare or property if they are willing to act on your behalf if that situation arises. So typically on the documents that we provide in this estate plan, we provide our contact information on those documents. So if it occurs that an individual acting on your behalf in terms of being your agent for power of attorney for property or healthcare, or doing something as a trustee of your trust, if they have a question or they want to get clarity on what they have to do in those situations, they can always contact myself or Monica and ask us what they should do next. So that was the power of attorney for healthcare in a nutshell. Now we're going to discuss the power of attorney for property. The idea is the same. The agent that you list under power of attorney for healthcare, they will be able to do things for you from a property perspective when you cannot do them on your own. So you are going to give your agent the ability to handle your money and make financial decisions for you, basically keep your life and your estate intact while you are incapacitated. If you regain capacity, then you can go back to making your own decisions. Again, just to recap, you have to make this document while you have mental capacity. If you try to execute this document when you don't have mental capacity, it's an invalid document, and your loved ones will again have to get a guardianship over you. If you appoint an agent, they will act in your best interest under Illinois law, and if somebody in your family finds that abuse has occurred, a judge can terminate them from acting as power of attorney for healthcare or property on your behalf. And if it's possible that one of your agents cannot act on your behalf because of sickness or death, we're always telling our clients to have a few backup options for the power of attorney for property or healthcare so that you don't have to come back and keep amending this document. So if you have a couple of options, that's always a good thing. Just to recap, you cannot have co-agents. So whoever you trust the most, I would always have them be first, and then so on from there. Now, the big difference between power of attorney for healthcare and property is that with your healthcare decisions, your agent may have to act in a more immediate manner. So I know that a lot of our clients may have relatives that they trust that are not in the United States. So I always recommend to my clients that for power of attorney for healthcare, try to have an agent that's a little more local if you can, or at least somebody in the United States who may be able to get to you in a quicker manner. And then you can list some loved ones that may be abroad. Power of attorney for healthcare, typically you don't necessarily have to act in an immediate manner as opposed to healthcare. So in that one, you can be a little bit more liberal. But at the end of the day, I always recommend go with the person you trust, even if they live in Antarctica, because that is the person that you trust the most. What types of things can your agent do for power of attorney for property? If, let's say, you were in a real estate transaction, halfway through you were incapacitated, your agent for power of attorney for property can help you close that property for you, or they can help sell your property. Either way, they can help pay your bills. They can help you make a contribution or withdrawal from a retirement plan, buy or sell stock, hire an attorney to defend a lawsuit if you're in an active lawsuit. They can help you run your business. It's really a wide range of activities. But at the same time, you can always limit the powers at the time you're executing the power of attorney for property. You can amend these documents at any point in your life. So let's say your first agent disappoints you in some way and you say, hey, I don't want this person to be my agent anymore. You can always come back and create a new power of attorney for property at any time that you want. But remember, once you lose mental capacity, we cannot amend that document anymore because it is completely your decision as to how you want your power of attorney for healthcare and property crafted. And once you cannot tell us what you want anymore, that document now becomes permanent.
Okay, so let's talk about these documents that we just talked about. Amaya kind of touched on this, but all the documents that we discussed, they're all fully amendable and revocable. So once you make them, you're free to modify them, delete them, create a new one. They're fully amendable and revocable, so they're not set in stone. Okay, so let's talk about the consequences of not having an estate plan. This is not a good situation to be in. So if someone passes away without the will and the trust having been into place, again, there's a probate estate that's filed in the county in which you lived. The probate estate process lasts for a minimum of 6 months, and it can be even longer if claims are filed on the estate. So all of this, again, could have been avoided just by doing a will and a trust prior to passing. Obviously, that would have been a lot cheaper and less stressful if the person had done that before they passed away. So without an estate plan, it could also result in a fight between your children and who is going to take care of them. If a person passes away without a will, again, if there are minor children, there would have to be a court case filed in the county in which the person lived. And there would be a process called a guardianship where a judge would actually appoint somebody to take care of the children. So again, this is very expensive, very stressful for the children and the other family members involved. It's best to have your wishes expressed before you pass away. Again, I kind of touched on this earlier, but if you pass away without these documents in place, children are allowed to inherit at age 18. And imagine how scary it would be if your children inherited all of your money at the very young age of 18. I know most of my clients would not want for that to happen. And over the years, I've been an attorney for a long time now, so I've had to sign these documents with clients at the last minute. I've been to nursing homes, I've been to the hospital, I've been to patients' homes when they were bedridden. And I can tell you that we did get the document signed, but it was very scary and stressful for the family to have been signing it at that moment. So what I would recommend is just don't wait to do this. It's really not, it's a very simple process. If you give us all your information, we make it as painless and easy as possible for you. It's work for us, but for you, I promise you it'll be a piece of cake. So if you are thinking about doing an estate plan and you want to proceed, you may be wondering what documents you need to provide to us. So all we need really from you is a copy of your warranty deed. So this would have been given to you at the time you purchased your house. It would be in your closing packet. So we need a copy of that. That's a legal document that shows that you own the property that you live in. And we also will send you a questionnaire that you'll fill out with your name, your spouse's name, where you live, your children's information, and then how you want the property to be distributed and at what ages and percentages. So that will all be in the questionnaire. So we email that to you, you fill it out and send it back to us. If you have any questions, we talk through everything so you feel 100% confident when you turn that over to us. One common question we get is what does my Illinois estate plan cover the property that I have in India? So the answer is no, because remember, United States and India are two different countries. So each country has their own laws of estate planning. In the United States, each state has their own laws for estate planning. So if you do have property in India, your US based estate plan will not cover property that's outside the country. So you'll want to contact an attorney in India. We refer our clients to attorney Srinivas Bave, who's in Mumbai. If you need his contact information, you can reach out to me and I'll be happy to provide that to you. So what do I need to do to create my estate plan? So you can call Ameya or I at 630-820-8877. We are open Monday through Friday or by appointment on the weekend. When you do initially contact us, we'll send you the questionnaire. Very simple, you fill it out. If you have any questions, maybe about who to appoint as executor or trustee or anything like that, give us a call. We work through all of that with you. Then after the questionnaire is sent to us, we review everything. If there's anything missing, we ask you for that information. And then we begin the drafting process on our end. When everything is completed and the documents are ready to be sent to you, we send them all to our clients via email. Our clients review everything. If there's any changes, we make those changes. And then finally, we set up a time to sign everything. If there's anyone watching from maybe like the northern suburbs or anywhere in Illinois, maybe you're not that close to Aurora, it's okay. We can do all of this virtually. So that becomes a big benefit for our clients. And then once everything is signed, we return everything to you and you are done. So unless you want to update anything in the future, you're basically done there. So it's really, we make it very streamlined for you. So we hope you'll give us a call. Even if you're thinking about it, we can work through any questions that you may have. So let me just make sure I've covered everything. So one thing is, many of you are wondering, maybe, is this a confidential process? So anything you tell us, this is all very confidential. We don't reveal it to anybody. There's a concept called attorney-client privilege. That means anything you tell us, the attorneys, it stays with our firm. It's not going out of this firm. We understand this is a professional process. We've been in practice for over 10 years. We do this every single day. So you are in good hands with us. We take it very seriously. And just to reiterate, we don't need any of your personal bank account information. So if any of you are concerned about sending that to us, we don't need specifics or really anything about your bank account. We just need your warranty deed and your questionnaire. Just to reiterate, we do other areas of law besides estate planning. I know I have a lot of clients calling me, asking me questions, but we do real estate transactions. So if you are buying a house or selling a house, make sure you tell your real estate agent that you would like us to represent you in that transaction, and they'll put our name on the contract. And just remember that you have the right to select your own attorney during the real estate buy and sale process. We also do personal injury law and workers' compensation. So if you get into a car accident and someone hits you and you sustain some injuries, whether it be whiplash or anything more, please just give us a call and we can tell you whether there's a case there. You might be entitled to some compensation. Or if you get hurt at work, give us a call. Again, we'll be happy to explain to you what your rights may be. We do probate estates. So for those of you that know somebody that hasn't done the estate plan, and if someone passes away, we can help them file the appropriate documents in the court. We do traffic tickets. I know everyone tries to be careful, but people do get speeding tickets or moving violations. So please give us a call if you have any of that. Property tax appeals, all the tax bills are coming out right now. So if you would like to appeal your taxes, we do that as well. And we do family law. So we do all kinds of different areas of law. If you ever have any questions, please reach out to us. Here's our contact information. Again, we are located physically in Aurora, Illinois, right by the outlet mall off of I-88, but we can work virtually with you from wherever you are in Illinois. So I will stop the share here and I will start taking some questions.
Thanks.
Oh, go ahead.
Chaitanya?
Yeah,
Go
sure. Yeah, before we take the questions, we sincerely want to thank you, a few individuals, and of course, Maharashtra Mandal. First of all, Monica and Amit, thank you so much for such a knowledgeable and wonderful session. Personally, me खूप दिवस झाले, estate planning is something that I've been deferring. करू, म्हातारपणी बघू वगैरे वगैरे, but I think it's high time that I should start thinking about these things. So quickly coming to the thank you note. Of course, thanks a lot to Maharashtra Mandal, Monica and Amit, both of you. Thank you, Madhav Kaka, Mandar, Ashish, Kashmira Magar, Deepali Sawant, Archana Bhargave, Jyoti Gogavle, Vivek Waluns, and of course, Prasad Athnikar. Thank you so much again. We can open up for Q&A now.
Just one question. We got a few questions here. We'll go over real quick and then we'll start with some other questions. So.
Here are some questions that we typically get from a lot of our clients when they call us for the first time. So these are ones that can probably apply to a lot of the people who are watching today. So the first question we get a lot of times is, people have children over the age of 18. Can my children be the executor of my will, the trustee of my trust, and the beneficiary of my estate?
So the answer to that question is yes. You can name a child to be an executor, to be a trustee, to be the agent for power of healthcare and power of attorney for property. Just make sure you trust your child to make those decisions in that stressful situation. You might want to have a conversation with your child. Hey, if I'm in this situation, will you be able to execute these duties properly, even under large amounts of stress? We also encourage parents to be aware that maybe naming children who are in college, it might not be the right time to appoint them yet. Maybe wait till they're a little bit older. So you yourself, you know what your children's abilities and levels are for appointing them. So just make sure that you are aware when you let us know.
Here's another question that we get. Are there any tax implications of making a revocable living trust?
So there are no tax implications of making the revocable living trust. There's no tax return that's filed. It's just because it's revocable, there are no tax implications.
Does your firm accept any legal plans through employers?
So one of the biggest benefits, if you are working for an employer that offers legal benefits, is that sometimes your estate planning process and your attorney fees are covered. So we accept the MetLaw or MetLife legal plan and the ARAG or AROG legal plan. So make sure you check with your HR department to see if that benefit is offered. If you have signed up for it, please, when you call us, let us know. If you haven't signed up for it, maybe sign up for it during the next benefit session and then give us a call. That's a great advantage for you because a lot of the times you don't have to pay out-of-pocket costs for attorney fees.
And then the last question we have here is, if you don't live that close to Aurora, what can I do to get an estate plan done with their office, but I don't want to come into the office?
So yeah, a lot of the times you don't actually have to come here physically. We do most of the work via Zoom or email or phone call. If you live a little bit further from Aurora, that's totally fine. You can come in on the weekend if you want to, or we could do it virtually on Zoom, FaceTime, or WhatsApp. And I forgot to mention one advantage to working with our firm is that we all speak Marathi. We all understand Marathi, and our mom, as you may know, also works with us. So it's a family-owned business, family-owned law firm. We'll take care of you like our family. Okay. All right. So we covered our commonly asked questions. So we'll open it up for any other questions here.
Hey, Monica, this is Aruna Dabodkar. I remember you from Diwali time at Tamane's house.
Oh, yeah.
Yeah, Aditi is my daughter. You may remember her. Anyway, like you mentioned about the taxes and there are no implications. What happens when the person who made the trust passes away and then the trust becomes irrevocable, correct?
It does become irrevocable, yes. But we're talking right now about the revocable trust. So I just want to emphasize to our viewers that doing the revocable trust does not create tax implications right now while they're alive.
So what are there tax implications after it becomes irrevocable?
There could be if the trust stays. So if you have minor children and the parents pass away, if the trust generates income of $600 or more, the trustee will find a tax preparer to file a income tax return for the income of the trust. Now, let's say you have older children and the property can be disposed of right away. So for example, let's say you have your primary residence in your trust and you pass away and your kids are all adults and they're acting on your behalf. At that point, the trustee can hire a real estate agent and actually sign. So the seller would be the Johnson Family Trust. And the trustee would be able to sign all the closing documents as trustee, so they'd actually be able to sell the house right away out of the trust without actually having going to probate. And then they can take the money and either split it amongst the siblings at the closing, or they can put the money in a state bank account, and then they could write the checks out. So if the family is older and all the kids are adults, they can pretty much distribute and dispose of all the property in the trust very quickly.
Yeah, and if you have any specific questions on taxation, we don't want to answer those on Zoom right now. So go ahead and email us and we'll be able to help you with that.
Here's one.
Okay, thank you.
Thank you. Here's another question.
Abhishek Gawanse, he says, hi, can we name someone in India to be the guardian for our children born here? Yes, you can. So when you have young children, typically the young children would probably go live with the guardian. So when children are really young, they really don't have an opinion or a say on where they go. They have to go live with the guardian. If that's really the person you trust, then yes, you can appoint a guardian that lives anywhere in the United States. Now, let's say your children are now 17 and 16 and they're almost adults and they've had a lot of relationships in the area where they live and they have good friends. Sometimes they can actually live with somebody like a friend or a family member local to where they are, but have a guardian that may be somewhere else. Because at the end of the day, everyone under the age of 18 in the state of Illinois needs a guardian so that, you know, people can sign up on permission slips or things of that nature. Everything that a parent would do for a child, the guardian would do as well. But at the same time, if the kids are almost to graduate from high school, they may just live with someone for that year until they become emancipated, and then they're on their own.
And it's important to get your children's wishes known too. You might want to ask them, like, hey, if something happens to mom and dad, are you okay with living with grandma in Pune or Mumbai? You know, like they might have opinions on that too. So make sure if they're old enough to understand that, you're asking them. I'll go to the next question here. Okay, someone asked, why does it get expensive for the probate process? Because when you do an estate plan, you're paying generally a flat fee for our services. When you go into probate, it's now litigation. So you're paying an attorney an hourly rate. Most hourly rates in this area are at least $300 or more. So you could be looking at 30, 40 hours. So you could do the math to find out why it's so expensive. It's just the expense is astronomical compared to the minimal cost it is to do the estate plan. Go ahead.
One caveat of probate is that you have to do a publication notice in a newspaper locally where the estate is being administered. And the publication has to, so there's a time period where creditors, so for example, let's say you have a MasterCard bill for $500 and you pass away. So MasterCard's going to be looking for you, right? So once they see that you have passed away, they're going to look for a probate estate. And if they see one, they're going to make a claim on your estate. So there's a 6-month period where you have to leave the probate estate open for 6 months for creditors to make claims. So all the property basically just sits in the estate for a minimum of 6 months. And that's if your attorney is working on just your case. But as you know, attorneys have many cases. So typically after that process goes, the judge won't actually sign off on closing the estate until they have seen that the publication notice has been filed and even if there is creditors' claims that they have been satisfied. So one problem with probate is that if somebody in your family, your heirs need the money, they will not be able to use any of that money until the judge has signed off that all claims have been satisfied and the probate estate can be closed and the proceeds can be passed out to the beneficiaries. So that's a big problem that the person who passed away won't see, but their family will bear the brunt of the expenses for the attorney and then the time it takes to just move that process along. That's why we always recommend doing the easier version, which is the trust and the will estate plan.
Someone just asked who executes the trust on someone's behalf after passing. So let's just like clarify here. If you pass away, you cannot have a trust anymore. It's over. You can only have a trust when you're alive and you have the capacity to sign off on it. So if you pass away without a will in the trust and you have assets that need to be distributed, we have to do what's called a petition for probate estate. That is an actual court case, a litigation case, court filing in the county in which you live. During that process, the judge basically determines who's going to get the money. So there's no trust involved there. It's just the judge following the laws of the state of Illinois. Again, like Amaya said, it could take a minimum of 6 months. Generally, it takes a couple of years to get the money that you would have intended probably to go to your kids. Takes just a lot longer and it's a lot more expensive.
Here's a situation that you can all contemplate after we're done with this presentation. So let's say you have no estate plan and you pass away. Let's say you have 3 kids and they're all discussing who's going to be appointed as the administrator in court. And 2 of them do not get along. Well, now 2 of the kids get their own attorneys, and now they start fighting in court as to who's going to be appointed as the administrator of their estate. Because when people don't get along, they typically do not agree in court either. Now the estate can drag out for a couple of years. Now both of them are spending money on attorney's fees. If that person had just appointed a trustee of their trust in advance or an executor of their will, none of that would be happening. So another good reason why we prepare in advance is to avoid any type of disagreements amongst your heirs after you pass away.
I have a question,
Yes.
Monica. Can I ask, or somebody else is talking with you?
Oh, no, go ahead.
Okay, my name is Shashikala Toke Das.
Mhm.
I'm Prakash, Sunita Toke's sister-in-law.
Yes.
And we live now in Ohio.
Right.
So I wanted to ask you, the will is made in Ohio. Is it valid in Illinois? Because our daughter lives in Illinois.
Well, different states give full faith and credit to the estate planning documents that are created in other states, but are you talking about someone that lives in Illinois or Ohio?
I'm right now in Ohio. We have been living here for last 30 years, 35 years almost. And our daughter is in Chicago.
Mhm.
And I would like to tell you that the will that I made was made in 2006. So it is quite old. Now, is there any expiration date for the will?
No,
should make new will?
I mean, there's no expiration date for the will. Again, you're in Ohio, so this presentation is for Illinois estate plans only, but I don't know of any will that expires. It's supposed to be valid throughout your life, and obviously it has to be valid after passing. So, you might want to take a look at it. So anyone on the Zoom, if you've already done the estate planning documents and you're using the Zoom as like a refresher to go over what it was, look through your document, read through it, because maybe when you created it, your children were minors and you've named your sister or brother somewhere. So make sure it's up to date. If your children are, in their 20s, 30s, 40s, make sure that you can appoint them. You can update the document to reflect that they can be the executor, the trustee, or your agent for power of attorney. Maushi, make sure you look through that document, look through the will, and make sure that everything is up to date. If it's not up to date, go to the attorney that created that will or an attorney. I'm saying that because you live in Ohio, otherwise we would be happy to do it for you. But go to an attorney and have them update it for the reality that we have now, okay?
Yeah. Well, the children, my daughter, she is adult, and she was adult when I made the will and the power of attorney. But I wanted to make the estate planning also. And I saw a lawyer here in Ohio, and she said, well, you have only one daughter. So you don't have to make any estate planning, because in Ohio, the law says that all the property of husband goes to wife and wife goes to that of husband. And then the will be, we have one daughter. So if none of us are there, then the daughter will be will be getting the will, and so she will get all the estate. But they said that I don't need to make any estate plan because this is so simple thing. You won't have any problem with the probate or anything. And basically the lawyer said that I don't need to make any estate planning. I just named all the money, the documents, everything for our daughter, so that she's the owner of all the things after me. But
Okay,
do you think
Auntie, let me answer your question. I know exactly what you're saying, okay? So just to reiterate, we do not practice law in the state of Ohio, okay? So whatever your attorney has told you there, I cannot comment on that. However, I'll tell you
we have
how
to get
Illinois.
it done everything in Illinois? We
Yes,
should
so
do it in
you live-
Illinois.
Well, you live in Ohio, so you should do your stuff in Ohio. If your daughter needs to do an estate plan, she should do one in Illinois. But let me tell you how, let me just reiterate how Illinois works. So in Illinois, if you have a child, they're entitled to 100% of your property if you pass away. It's called per stirpes, okay? If you have 2 children, they're entitled to half-half. If you have 3, then it's 1/3, right? You are
Right.
correct that if you pass away, your daughter will inherit your property in the state of Illinois. So I'm talking just in Illinois. However, as we discussed, if you don't have any documentation, your children are still going to have to go through the probate process to inherit your property. Because at the end of the day, society and state law, they don't know that this person wanted you to have this property. So now we're going to have to prove it in court. So in Illinois, let's say you have 1 child, you have a house and some bank accounts, and you did absolutely nothing. Now, when you pass away, your child is going to, let's say you lived in DuPage County. Your child now, to inherit your property, they're going to have to file a probate estate in DuPage County. Of course, they will inherit your property, but now they're going to have to wait 8, 12 months to actually have that property become titled in their name, to do something with it. That's why we do this estate plan, so this property can be transferred to your children rather instantaneously than having them to go through that process of probate.
Estate planning should be done in Illinois or Ohio. It doesn't matter.
No,
Does
it
it
matters.
matter?
It depends on where you live.
Yeah, it depends on where you live. So for all of us on the Zoom meeting here, we're all mostly in Illinois. So you want to do your estate plan in Illinois. It depends, whichever state you live in, that's the state you want to do your estate planning. So I'm going to go through some of the other questions here. If one has come here from another state, does he need to start a new trust or need some changes? If you are established in Illinois, you plan on living here, I would go ahead and do an Illinois estate plan. So any assets that you acquired here are going to be transferred to your heirs properly. So if you're planning on moving back to that state, maybe you don't need to do a new one, but if you're here to stay, I would definitely do one here. Let's see what else here. We've covered.
Oh, here's one. Some people are asking about their stock accounts and HSA accounts, brokerage accounts, right? So if you list a beneficiary on a stock account, a brokerage account, a life insurance policy, that will trump anything else. So if you have Mike Jones as your primary beneficiary, if you pass away, that account will go to that person. So if you have a primary beneficiary and they're still alive, that account will go to that person regardless. Let's say you put your friend Bob as the beneficiary of a brokerage account, but you have 2 children named in your trust. Well, that account's not going to go to your 2 children, it'll go to Bob. Or if Bob predeceases you and you have Bob Jr. as a secondary beneficiary, it'll go to Bob Jr. So with my older clients who have adult children, I say for those types of accounts, you can put them directly as the beneficiary. If you have minor children, I always say make the secondary beneficiary the family trust, because now those distributions, if you have to use those accounts, can be dictated out of the terms of the trust. So it's really a situation of where you are in your life for those types of accounts.
Okay, thank you.
Thank you.
I'll contact you. I have written down your contact number, and I'll talk with you more later. With maybe by my daughter and myself, we both will talk with you.
Very good. Okay, thank you.
No, Anna, this is Maisakar Kaka. I had one question.
Yeah.
When we have IRA accounts with any institution, is it advisable to transfer those IRA accounts when I'm alive?
Transfer the accounts.
IRA accounts.
You mean giving a gift to somebody, like your children, taking the money out and giving a gift?
Yes.
I mean, you can. It's obviously a personal choice. Some parents are more generous than others, but yeah, you can give a gift to your children. It's $17,000 a year. There's an annual exclusion per person. So you can definitely do that, or you can leave it to them.
I mean, the real thing you should just do is just put your kids as the beneficiaries on your IRA. So if you pass away, if you have 2 children, they can just take it 50-50. Here's the thing, when you pass away, your kids receive a step up in basis on assets. If you give it to them during your lifetime, like some people are like, hey, I want to give my house to my kid. Well, if you give it to them during your lifetime, they don't get the step up in basis that you would if it transfers after your death.
Okay, thank you.
So,
And another question, who should have once you do the estate planning, who should have the copies of the estate planning documents?
Okay, so one advantage to working with us is we have a copy of all the estate planning documents. So if there's a fire in your house or you misplace everything, we do have a copy of all the documents. So people contact us all the time. I need a copy of this, that. We do have it. I would also recommend giving it to the person that you've named as your trustee. Or if you don't want to actually give them a physical copy, let them know where it's in your house. So if it's in a file cabinet, you know, in a red folder, let them know exactly where it is. If you do trust your children to have it, so to make a copy of everything and give it to the person you've named as your executor and your trustee.
Thank you very much. Great presentation, guys.
Thank you. Someone just asked, if I do estate planning in Illinois and then relocate to some other state, what happens if I don't, what happens to if I sell something?
I think I understand what Samir is asking. Some of my clients, you know, their jobs take you all across the country, right? So they keep a house here and then they move to California, but they still have the house. So if you have already deeded a house in your trust in the state of Illinois and you move to Arkansas, for example, it's perfectly okay to keep this trust in the state of Illinois with your house in it. And then you can move to Arkansas and make another trust and put a house that you've purchased in Arkansas in that trust. At some point, if you end up selling this house and you've already moved to Arkansas, you can keep that trust. And in the future, if you move back, you can reuse it again. If there's nothing in the trust, it's kind of just a piece of paper.
Perfect. Thank you.
Looks
Quiet.
like we lost Monica. Monica, are you there?
I think maybe the Zoom time is finished.
It's not Zoom time. We have unlimited time. Maybe they are having problem with the internet. I will contact her.
काही क्वेश्चन्स आहेत का आता अजून? ठीक आहे. थँक्यू एव्हरीवन. जर क्वेश्चन्स नसतील तर वी कॅन स्टॉप द युट्यूब लाईव्ह. आणि आय थिंक मोनिकाच्या इंटरनेटचा इश्यू आहे बहुतेक. तर एनिवे विल स्टॉप हिअर. इफ यू गाइज हॅव एनी क्वेश्चन्स, यू कॅन पुट इट इन अर्थविचार, or you can send it to Karyakarni and we'll send it to Monica. And Monica, I think on the last slide, she gave the numbers and email address as well to contact. So thank you everyone. आणि आता आपण सेशन क्लोज करूया. See you in the next